So, Deirdre, 2023 has definitely been an eventful year in the sector. We've seen some game-changing judgments come through the courts. We've also seen lots of legislative changes which have impacted areas ranging from occupiers' liability to data protection claims. And of course, the personal injuries guidelines have remained a hot topic throughout the year. But what for you were the most notable developments?
I think, Laura, as you say, it's kind of been a year of learning for us. There's been lots of judgments. We've seen the kind of real world effect of the personal injuries guidelines. So not just the kind of headline news articles or press releases, but kind of the real life impact. And we've had a few judgments coming out that might help us to understand how the guidelines are going to be applied in assessments. And one of those was a recent Court of Appeal judgment in Tara Wolf. So that judgment focused on actually how PIAB assesses a plaintiff's injury. And in that case, as you know, the plaintiff challenged, or claimant at the time, challenged PIAB's assessment of her injury. And she argued that because she wasn't given any written assessment or written kind of rationale for their assessment, she was hamstrung and she couldn't really decide whether the assessment was correct or incorrect, or whether she should accept or reject. And she said that her solicitor had difficulty in advising her of whether the assessment was appropriate or not for her injuries. And in the Court of Appeal, she didn't find any solace. They didn't agree with her, and they felt that really there was no obligation on PIAB at all to give any sort of written kind of rationale or detail about how they reached their assessment. But when the case came before the Court of Appeal, they took a kind of a different approach. And they said that the calculation itself was of critical importance to a claimant in deciding whether to reject or accept an assessment. And they felt that a claimant should be given as much information as necessary for them to be able to actually understand the assessment or how it was reached. In that case, that assessment has been sent back to PIAB to have them look at it again. But I think that was a case that really kind of piqued my interest, because I've spent a lot of the last year looking at this area and kind of discussing and thinking about with clients the lack of transparency in PIAB assessments. And I think it's something that's kind of really important to consider. Really, it's very difficult on occasion to discern why PIAB has decided that a plaintiff's injury fits into the bracket that it's, the category that it's put into. And I think just like a practical real world example of that I've dealt with is a case that I had over the last probably 18 months, where it was clear from the bracket that they'd slotted the plaintiff's injury into that they'd completely disregarded her own medical report and seemed to have just relied on the medical report they'd commissioned themselves, but without any kind of, written assessment or any look behind the curtain. We were kind of operating in a vacuum. And I think if we had had access to the rationale of PIAB, we would have been able to, firstly, it probably would have increased the likelihood of the plaintiff accepting the assessment in the first place, because she would have been more informed. And secondly, it would have kind of decreased the time period that it took for the two sides to come to an agreement on the value of the claim and for the claim to ultimately settle.
Yeah, and it will certainly be beneficial for all parties involved to have more certainty and clarity around how PIAB actually reached its assessment. The question then is, how much more detailed will the PIAB assessments actually be, and will this then lead to delays in the PIAB process? So the Court of Appeal specifically said that in certain situations that one simple sentence might suffice in terms of reasoning, and then there would be other cases where more detailed explanations would have to be given. So it's very much on a case-by-case basis, and it's inevitable that in certain situations that, it will take PIAB more time to assess a claim. So moving then, Deirdre, to the valuation of multiple injuries under the guidelines. This is something that was looked at and considered for the first time in the Lipinski case in 2022 in the High Court. The last 12 months have seen a lot of judicial commentary on this point.
Yeah, as you said, we discussed Lipinski in some detail in our review last year, and that was kind of the first real in-depth analysis of how the guidelines would be applied in cases of multiple injuries. And that's obviously something that we deal with a lot. It's unusual for a claimant or a plaintiff to have one headline injury only. They usually have a couple of injuries that kind of overlap a bit. And if you recall, in that case, the court applied and kind of valued the dominant injury, the main injury, and then applied an uplift for the secondary injury. And they also stressed that the kind of aim and the outcome that they wanted to achieve was a fair and proportionate compensation for the plaintiff. And I think that proportionality is something that comes through all of our decisions that we've seen even pre or post guidelines on the assessment of damages, and that's kind of the prism that the courts have to operate through at all times. So since Lipinski and throughout 2023, there have been a couple of judgments that have addressed this issue of the assessment of multiple injuries. But inevitably, different High Court judges have had different approaches and have kind of come to their assessments in different ways. So I think really where we should be looking to get clarity in this area is the Court of Appeal, because that's going to be where the guiding principles come from. And the recent case of Zagainsic, and apologies if I've pronounced that wrong, but I did look it up and I hope I have it right. That was a Court of Appeal decision that was handed down in the last couple of months. And in that case, the court endorsed the High Court's approach in McEwen for all. And in that case, if you remember, the High Court looked at each individual injury and assessed it and valued each individual injury, and then applied a discount to make sure that there wasn't any overlap of compensation. And the Court of Appeal kind of expressly said that this was a good way of looking at the assessment of multiple injuries. And they also again touched on the importance of proportionality and what they called a kind of a reality check, that a court assessing multiple injuries should look at the overall award at the end to make sure that it was proportionate to awards for similar injuries and proportionate to the scale of injury. So I think, as I said, looking into 2024, I think it's the Court of Appeal that is going to be kind of guiding this area. And in the meantime, I think Zagainsic is going to act as kind of a guideline in itself for how the guidelines are applied in multiple injury situations.
Yeah, and even from the point of view of the guidance that was set out in McEwen Ferrell is, some very practical steps in terms of advising clients on setting reserves. Finally, then the Premor test for delay is set to be re-examined by the Supreme Court.
Yes, and that arose out of a case against a backdrop of the courts becoming more generous towards defendants who bring applications to dismiss plaintiffs' claims for delay or want of prosecution. There have been a number of judgments over the last while where plaintiffs' claims have been dismissed. And as you touched on, the Premor test was the test that was applied in those cases. And we'll know from our student days, because it's been around as long as we have been, that the test was the delay inordinate, was it inexcusable? And then if those two limbs are hit, does the balance of justice favour the plaintiff's claim being dismissed? And the Supreme Court re-examined the area arises from the Kerwin case, where the High Court and Court of Appeal both found that a 5-year delay on the part of the plaintiff was inordinate, inexcusable, and the balance of justice lay in his claim being dismissed. But that plaintiff applied to the Supreme Court for leave to appeal. And the Supreme Court have allowed that. And I think they flagged that this is an area of public importance. I think given the length of time that Premor has been in operation, I think they want to look at it and see, is it appropriate in today's world? Is that the appropriate test? And as I touched on, the leaning of the courts in recent times has been in favour of the defendants. So if this test is going to be revisited or maybe recalibrated by the Supreme Court, it's something that our insurer clients need to be really aware of and keeping a close eye on if that kind of regime is going to change.
Yeah, and I think that's something we'll be very much looking out for into 2024. And I'm sure we'll be sitting here chatting about that this time next year.
Thanks, Laura.